Today it's September 17th while I'm airing this, and this is going to be a supplementation to Emerson Bar Review number 10. It is a torts defamation summary and discussion with a couple of extra cases. And we might even go ahead after this and read a California bar case. But for now, we're just going to do a overview of defamation, which actually has some other umbrella cases under it, like invasion of privacy, which we'll get in number 11, okay? Because I have to keep this condensed. And so I'm going to go over the Constitution a little bit as it relates to defamation. Now, you probably heard a lot recently about this Amber Heard case with Depp, and it was highly publicized. A lot of people followed it and watched it. Honestly, I did not watch it. Evidently, Amber Heard gave an interview to somebody who she discussed her perception and her lived experience about how she felt being mistreated, and the ACLU was trying to use her as a poster child for women. Even famous women can wind up in relationships where they're taken advantage of. Who knows? Suffice it to say, the Virginia courts found her liable predominantly. Both of them were libelous to a certain extent. She got hit the hardest. So it's sort of like a wash. I don't know. There's supposedly an appeal coming up. I don't know. Anyway, so here's the playlist. I'm going to put these links below. And maybe you can make a little more sense out of some of the stuff that you see if you're not studying for law school exams or bar exams. But with the essays, it's important to know a lot of different details, and or say you're doing paralegal studies. By the way, I do have paralegal under my belt and a master's. So, and law school, of course. But anyway, so this is the playlist, and this is what we're expanding upon. So actually, Emerson spends a great deal of time going through the topics of defamation. I took the way he outlined it and took a snippet from the video, put it up here, and combined the relevant, important parts. So what I'm just going to stick with is the defamation portion. I'm not going to get into invasion of privacy right now. Intentional infliction of emotional distress sometimes goes with that. Defenses and Constitution. So those are the areas I'm going to be covering right now. So this is just a quick overview, and I'm going to show you a couple cases. So generally the main elements are an allegation of fact that harms the reputation of the plaintiff. Now, how is that so? Well, you're going to want to have, at common law, 5 elements covered to have a case. And it depends on if the person is a private figure or a public figure. And we're going to get into that, giving some case law examples. Okay, so opinions, insults are not considered defamatory. Also, like if you're joking around, parody, and it's not, there's like nuances to this. So when you hear a case or read a case or you're given a question, keep in mind it's got to be false and defamatory. What's defamatory? It's a material fact concerning the plaintiff that's understood in a defamatory sense, disparaging, loathsome disease, liar, cheat, etc., and that is published by the defendant to another. So, and then it actually has to cause harm to the plaintiff's reputation. So how is the plaintiff going to prove this? Well, some are per se. You don't, it's presumed with certain things like loathsome disease. With other things, it's going to be arguable. So the defamatory statement can be made negligently or intentionally, either one. And any person or anyone that reiterates it like an echo chamber can also be held liable. Damages, you have to have actual harm, and it's dependent on whether it's libel or slander. So, libel is more serious than slander, and it's because with libel, it's something tangible, it's recorded, it could be a video, it could be a picture, a blog, digital copies. Damages are presumed, okay? So it's worse because it's a durable form of communication. Now, the other kind, of course, is slander. Slander is spoken or fleeting forms. They call it a fleeting form because it's not memorialized. It's not recorded. So it's not of record. You can be using sign language, or you can be speaking to another person, and you can say some things about another person that are offensive, and that could ruin their reputation. You got to prove damages, and you have to prove special damages. So slander per se, damages are presumed. For example, if they're going around saying something that's a crime of moral turpitude, the person is depraved, or they're a thief, or, so things like that, moral statements about a person that are not true. Okay? There's other segments. We're going to go into this more detail next time. But like if it adversely affects one's business. Now, here's some key points. I brought this up earlier. Public figure or private figure. Okay, so this is going to make a big difference. If you are a private figure, you're going to have a lower standard, a lower threshold than a public figure. If you're a politician or you're one of these public influencers like Kim Kardashian or something, people can probably make memes about you and joke about you more that would offend a normal person, and you can't really sue them for. You're not going to have a good case for defamation unless you can prove these certain malice. It was malicious, intentional. So here are some defenses: consent, truth, if it really is true. Absolute privilege. Let's say you're in a hearing and you're testifying about something that occurred or something that you saw. You're not going to be able to. They're not going to be able to sue you. So let's take the case that was recently, not too far long ago. People came up and testified for either party. They called witnesses. They were subpoenaed. These witnesses are protected for giving their witness. They can't be sued for giving their perception of what they perceive as a fact or what they've observed. Okay, so. And government officials, different sort of capacities are going to protect a person from being able to discuss something that might be considered defamatory if, so they can have qualified privilege and malice by publication if they're malicious in how they do. Oh, wait, this is qualified privilege. Should I jump over? Okay, absolute privilege is what we were just on. Even if a person has malice with absolute, they still might be immune. Now with qualified, that's different because, okay, let's say you're reporting on something. You're a journalist, and you you're reporting on it, and it's to protect the public's interest or protection of a third party, and you publish it, but you add in a few extra things, or you give a little bit of a bent to it that's going to make it more exciting or inflammatory, and like sensationalism, right? Then you forfeit your protection. So the immunity is only for what is reasonably necessary to report the facts with qualified privilege. Now, there's constitutional privileges as a defense. So one of the questions you're going to ask, again, to reiterate, is the person or plaintiff a public figure or private? You need to know that because the standards are different. Also, is this a matter of public concern or is it private concern? Now, here are some seminal cases. I picked, I think, 3 or 4. Forget. Let's see. New York Times versus Sullivan. You ought to know that if you're a law student. JD. This is classic. It's you can go to OIES. Let's see if I have this here, and you can hear the oral arguments. You can listen to the facts of the case. New York Times published an ad that was contributing donations to defend Martin Luther King jury on perjury charges. The ad contained several minor factual inaccuracies. The city public safety commissioner, Sullivan, felt that the criticisms of his subordinates reflected on him. Even though he was not mentioned in the ad, Sullivan sent a written request for the Times to publicly retract the information as required for a public figure to seek punitive damages in a libel case under Alabama law. When the Times refused and claimed that they were puzzled by the request by Sullivan, a group of African American ministers mentioned in the ad, a jury state court awarded him $500,000 in damages. The state Supreme Court affirmed, and the New York Times appealed. Now, this was the question before the court. Did Alabama's libel law unconstitutionally infringe on the First Amendment's freedom of speech and freedom of press protections? Conclusion. Now, to sustain a claim of defamation or libel, First Amendment requires that the plaintiff show that the defendant knew that a statement was false or was reckless in deciding to publish the information without investigating whether it was accurate. In a unanimous opinion by Justice Brennan, the court ruled for the Times. When a statement concerns a public figure, the court held it's not enough to show that it is false for the press to be held liable for libel. Instead, the target of the statement must show that it was made with knowledge of or reckless disregard for its falsity. Brennan used the term actual malice to summarize the standard. Although he did not intend the usual meaning of malicious purposes, in libel law, malice had meant knowledge or gross recklessness rather than intent. Some courts found it difficult to imagine that someone would knowingly disseminate false information without a bad intent. So, I could probably put this link below, but all you have to do is go to OIES and just look it up. So here's the publication and some images. And actually, let me undo that real quick. Okay. So here's another case that I thought was relevant. Now this is Hustler versus Fallwell. Excuse me. There was a cartoon put up on a televangelist, Jerry Fallwell, I believe it was. And Hustler was a seedy magazine that objectified women and did articles that were lewd and crude and lascivious. I think you needed to be 18 or 21. I don't even know if they still have it. But this was a 1988 case. You can find it on Oyas as well. And I did a quick snippet. Now this guy is the Hustler magazine founder. He got really rich. He's kind of like the Playboy. He's not Playboy, but he's the same genre. So this is an article that basically said that he was like an alcoholic or something. There was a cartoon, and that he was incestuous. Now, it was meant to be parody. It was meant to be a joke, but somehow Fallwell got wind of it. He was very upset and sued for intentional infliction of emotional distress and defamation. And basically, he won in the lower courts. However, when it made it up to the Supreme Court, they said, this is a constitutional law issue. Because freedom of speech and parody, joking around, people can joke around about public figures. People should know that it's meant to be a joke. And it's free speech, there's no actual malice, okay? So that was the majority opinion. Okay? So the other case is Gertz versus Welch. Now this is with a private person. We just went through two public cases. That person was a government official, or Sullivan was a public figure, basically. Now, Gertz versus Welch was a private person with matters of public concern that involved negligence, and actual damages have to be proven. Now, don't think that's like all the way across the board, because if a defamatory statement is made that's of private concern, not public, Gertz does not apply. Okay? So next time we're going to be talking a little bit more in detail about these harms to the person, emotional harms, reputation, that sort of thing. We're probably going to cover invasion of privacy. I'd like to talk about the Gawker case. So this is related with defamation. It's moral character. And I want to thank you for listening. And until next time, you can just watch this as many times as you want. There's sort of like a little outline. I put in the main points that you need to know for common law, defamation, and you can watch these longer videos by Emerson. He goes into great detail. I think there's two of them. This one's 50 minutes, but it goes into much more detail. Practice questions help. And thank you for watching. Take care. Bye.